We have our next item on the agenda is the report of the Legal Technology Task Force that was scheduled for, or a little bit early, just a little. But she's here, so I think right now we're going to call it. And I'm going to introduce Jenny Durkin, who is our task force chair, as well as Craig Shank, ad hoc member, and practice management advisor Margot Green, as well as advancement director Kevin Platchy. Welcome, everyone.
Thank you so much for having us, Madam President, members of the BOG. We have a number of slides which we will try to get through quickly. We won't adhere to every single one of them, but want to thank you for this presentation. I used to think that the worst time to present was after lunch. I will revise that. It's after a budget discussion. And so I hope you listen to this report. It represents an enormous amount of work. I want to thank the Board of Governors because I think you were very forward-looking to make sure that we had this committee and had a way to look at these issues. It has developed so quickly that I think one of the challenges we had as a committee was actually not becoming obsolete as we went because the technology has moved so rapidly. You can move to the next one. We've got a number of things we're going to cover today. We're not asking you to make any decisions on the recommendations. At the end, all we will ask you to do is accept the report. As you will see, it's very dense. Some of you may have read through it. We should be able to get our report on tapes so you could listen to that at night. But we are very hopeful that as we work through this, we know there may be additional questions down the road because it's a very dense and very important topic. And I think one that's of great interest. As you know, the Supreme Court has also had its own group looking at some of these issues, as had the State Attorney General. I want to thank particularly Margot and Kevin, who not only carried such a load here, but made sure we stayed aligned with those other efforts, and also the members that were on the committee. I won't go to each one of them, but we were really fortunate to have broad participation. And I think, again, the board was really smart to make sure that we looked at not just geographic diversity, but areas like the courts, the law schools, and the like. We quickly learned that with the appointed members, we were not going to have enough people to get this work done because there was so much of it. So we opened the doors and went to the people who had applied and maybe had not been chosen in the first round, others who had demonstrated both either technical interest or abilities. And as a result, ended up with a huge effort over hundreds of hours looking at thousands of records and doing research and looking at what other bar associations and private industry was doing. We did a number of what we called field trips where we went to see how entities like Microsoft were incorporating AI in the everyday work of their legal departments so we could get some sense. And I think remarkably also because of the support of the Board of Governors, we're able to do a member survey, which was really critical for us to pin our work to where our members were, what they needed. And for us gave us great information about that. We are a mandatory bar. I was reminded when I was Board of Governors, always trying to remember that we have to center our members and make sure that we're doing and giving them the tools they need to provide the excellent professionalism that our bar members do provide. And at the same time be hewn to really important principles: access to justice, equity, the courts. We've talked a lot about the rule of law in the last year, and I think that the work we did here is going to be so central to ensuring the rule of law going forward. We'll go through the slides quickly, but the background, you know, everyone saw that we were going to be, it is just such a fundamental shift right now. AI has already started to change every industry, and the law will be no exception. And as we go through these, we're going to hold questions until the end, if that's all right with the board, so that we can get through, but then get to the nub of things.
Okay. So just a little bit of backdrop here. As Jenny mentioned, the task force brought together a wide range of different parts of the legal ecosystem. And with that broad representation, it was natural to approach this as a systems view rather than as a narrow, will this particular hallucination get me thrown out of court view? And I think that was really important. We avoided some of the things that should be settled law or already are settled law, and instead focused on a key issue. And that is, these new technologies represent a structural shift in the foundations of legal practice, in the foundations of the courts, in the foundations of client expectations. AI is already transforming legal practice. All of us have experienced it in some fashion in our day-to-day activities. So the systems view matters because as the operating system for our economy, if the legal ecosystem falters, frankly, the whole system stumbles. And that goes directly to the credibility, legitimacy, and trust in these fundamental societal institutions. That was where this report centered. The task force's recommendations are aimed at very simple goals that were aided by the original charter that you all gave to us and by the broad representation and the leadership that the task force had. Washington's legal ecosystem needs to be not left behind by this transformation. Our professionals, our institutions have to be ready to serve clients, serve communities, and deliver all of this effectively in a rapidly transforming digital world. Overall, the vision is a more capable, responsive, resilient legal ecosystem, and one that supports our professionals, our members, through this disruption while expanding access to justice and testing new models to widen the availability of legal services. So one of the things that we took away is WISPA members are at very different stages in their approaches to technology. And it is critical that we meet members where they are and not try to talk at them at very different levels than where they presently have reached. Some are experimenting, some are just beginning, some are uncertain about whether to touch this stuff at all. So we need to meet them where they are. And at the same time, technology is no longer optional. It's both a tool for practice, but it's also the subject matter of our practice. Our clients coming in with issues, with concerns, with problems, our individuals proceeding in court are facing issues that are AI influenced, even if we choose not to use the tools themselves. And that's a critical piece, is that we have to get informed enough to be able to serve our communities. Washington is well positioned to lead. We've got a visionary bar, we've got direction, we've got capacity in our law schools, we've got capacity in really profoundly influential tech companies who could help us while protecting the public, upholding our values, and expanding access to legal services. So that's why this report translates these realities into 10 key points that you'll see in the paper and about 4 dozen specific recommendations. We know that that is too much. That sort of 25 pounds of coffee beans is too much to fit into the 5-pound sack that we have right here, right now. And it wouldn't be useful to spend time on each recommendation, but we do want to give you a sense of the flavor and the direction and how we went about this. So we've grouped these, beginning with the very first and most important thing, which is the role of the individual practitioner. Above all, effective outcomes across this are going to depend on member engagement. And then we'll move to key issues around the institutional responsibilities of the Washington State Bar Association, the courts, law schools, and policymakers. And so with that, I'll hand it off to Margot.
Thank you, Jenny and Craig. Are we good? Okay. I'm going to be walking us through the first cluster of key points, which for this presentation, we're calling competence and capacity. These are key points 1, 2, and 3, and together they really lay the foundation for the rest of our report. So this cluster focuses on 3 things. First, what individual lawyers need to do. Second, what the bar must do to support them. And third, how we ensure that support reaches the full range of practice areas across Washington. So the message here is actually quite simple. Lawyers cannot do this alone, and the WISBA must evolve to meet the moment. This is a moment defined by rapid technological change, growing member needs, and a responsibility to lead in a way that's thoughtful, inclusive, and grounded in our values. So key point 1 is about individual lawyers. It emphasizes that legal professionals, not vendors, not the WISBA, are the ones who ultimately decide how technology shapes their practice, their client outcomes, and their ethical responsibilities. So let's take generative AI. It's already offering new efficiencies, but it also raises serious questions about bias, privacy, fraud, and evidence. Because of that mix of risk and opportunity, lawyers can't wait for perfect guidance. They need to take ownership of their learning and their growth in this space. So to help lawyers take that next step, the report recommends a few practical, doable steps, and here are just a few. First, start small and learn fast. This means experiment in low stakes ways. Second, stay curious and flexible so change feels manageable, not overwhelming. I'm not saying not frustrating. We know technology can be frustrating, which is why Craig is hosting our presentation on his laptop this morning. And third, treat tech learning as an ongoing habit and not a one-time task. So this is not about mastering every tool, but this is really about developing a mindset to keep adapting as the tools evolve. Okay, oh, you're already ahead of me. Key point 2 shifts the focus to the WSBA itself. If lawyers are expected to build their competence, they need support. And members told us clearly in the survey, they need a trusted place to turn for help for navigating all of these changes. And the bar is uniquely positioned to provide the support. But right now, there's a gap between members' need and what's available. So the survey data made this clear. 70% of in-house counsel are already using AI tools, but in small and mid-sized firms, that number drops to just 22%. 69% of lawyers said they'll need new skills to use AI responsibly. So to bridge that gap, the WSBA must build its own internal capacity and our infrastructure. And the report includes several recommendations to help do that. A few key ones include 1, developing a strategic technology plan with goals, timelines, and regular progress tracking informed by ongoing member surveys. And 2, centralizing technology resources in a user-friendly hub with curated checklists, policies, vendor guides, and training materials so members can easily find what they need and choose formats that reflect diverse learning needs. So this is about making the WSBA a consistent and visible partner in our members' tech journeys, one that's proactive, coordinated, and responsive to evolving needs. And key point 3 zooms out to the diversity of practice settings. Large firms and in-house counsel are ready for advanced training, but solos, small firms, and rural lawyers often need practical tools to help them manage the daily demands with limited resources. And the WSBA must tailor its support to meet those different needs. So here are a few recommendations to turn that into action. First, expand free and low-cost CLEs on technology so access doesn't depend on firm size or budget. Second, consider a tech-focused MCLE requirement. And third, explore how technology competence might be reflected on the bar exam. So the goal is to make sure that technology readiness starts early and continues throughout a lawyer's career, no matter where or how they practice. So with that, I'll hand it over to Jenny, who's going to walk us through ethics and safeguards.
Thank you very much. I really want to emphasize that we are at this, what I call a buggy whip moment. And the changes that are happening with AI are going to fundamentally shift everything in society, including the practice of law. And it is happening at such an accelerated pace that our members are the ones who are really looking to us for guidance. And this is particularly true in the realm of ethics. Most lawyers now have read all of the scare stories about hallucinations and citing cases that didn't exist. And so we hear these numbers where you have in-house counsel and resource corporations over 70% using AI tools. But in the practices that most of our lawyers practice in, that drops so precipitously, and people don't know what they can use and what's ethical to use. And we're moving from a time when it is viewed almost unethical to use it to a time when it will be mandatory that you do use it. I really want to thank the Committee for Professional Ethics because they worked very closely with our committee And Michelle Carney was a really active member in both to make sure that we were keeping those things aligned. But if you look at where we are today, that we've got to do some very basic things. We have to have baseline ethical standards so everyone knows what is expected, but they're elastic enough that as technology shifts, people know what to do. We have to have those published and clear guidance and the ability for people to call in to get more guidance. And we think we also have to have a really ongoing evaluation here at the end on the ethical framework as technology changes. We also know that cybersecurity is kind of both something that is a warning sign, but it's also emblematic of how much work we have to do. Because the majority of the members of the State Bar Association are confident in their cybersecurity. Yet when we asked additional questions, it was clear that most of them were not taking some very fundamental steps to ensure the confidentiality of their work and basic cybersecurity. We need to take the lessons from that and know that as we move into even more technology and capabilities that are hard to understand, or that people won't even have understanding of what the underlying algorithms are for those technologies, that we really are providing very clear guidance for our members, and that we as a bar association are staying abreast of those technologies and continuing to evaluate what that means for our ethical responsibilities. We're going to talk some more about this, each of us are, but one of the critical things we believe our committee came away with is we have to strengthen our courts' capabilities. And if we really want to advance justice and the rule of law and access to justice, we know that this digital transformation cannot leave our courts behind. And there will be an array of issues that go to, what's admitted into evidence, who can come before the courts, can it be used in translation? I mean, it goes to almost every aspect of the courts, but we really want to make sure that there is the infrastructure for the future, and not just the physical infrastructure for the future, but the capacity within the courthouse for the judges and courthouse staff to understand what technology is available and to use it. You'll see that we're making recommendations too to unify some of our court systems so that we don't end up with, some courts offline for a period of time, others aren't. We know that this is one of the things that the bar is going to have to come back to and work with the courts on. And here's the part where it's never good to have it after a budget meeting. But, we are promising that we will stay engaged with the Board of Governors and others and help others to make sure that we can make the case for the courts so that they are there and ready for the next stage.
So we call that good?
Yep.
Let's move on to sort of the second part of our institutions. Courts first, and now let's look to the lawyers of the future. Education, our law schools. The readiness for our future lawyers is crucial. The work that an entry-level lawyer will do in just a few years is going to be substantially different from what they are doing today. What they're doing today is substantially different from what I did a lot of years ago. Figuring out how do we get individual students, how do we get whole classes of students fully ready for this transformed era is important. And I really want us to internalize that their world is going to be substantially different because many of these knowledge-based tools are able to do some of the work that a first-year lawyer would cut his or her teeth on. We need to find a way for individuals to enter the practice candidly at a higher level than we all did. This is going to be important. So that takes tweaks in curricula. It's going to take maintaining practice-ready training and ways to assess student progress on an ongoing basis. This is not going to be a one and done, and it is not something we can bolt on. It needs to be integrated, and I cannot overemphasize how important experiential learning is in that, getting this into the clinics and getting it evaluated in the context of the clinics, advancing the clinics in their role in law school. I'm going to shift to our final grouping, trust and oversight. Our final grouping centers on the issues that we recognize the public is already turning to AI tools, often without attorney involvement. And that creates opportunity and risk for us. We're recommending standards, consumer protections. We're recommending a recognition that this technology influences the way people think about their access to legal information and their access to services. So, So the public's already turning to AI for help without lawyers, unhindered by counsel, I sometimes describe this as. And at the same time, that's not necessarily getting them the right answers. The goal here is to leverage AI to expand access to justice, but set some ethical boundaries and provide some clear information, guidance, and education for consumers to help them understand what this information is that they are pulling from a given chatbot or whatever it looks like in 3 years, pulling out of their glasses. We also want to establish clear guidance to help identify what misleading uses of AI would look like in that setting. I'd also recognize, building on the cybersecurity comment that Jenny mentioned, I know we don't want to be the next version of the Panama Papers, the Seattle Papers, the Yakima Papers, the Spokane. That doesn't have a good ring to it. But beyond that, there are the permitted uses of consumer data, the permitted uses of even potentially data that arises in an attorney-client relationship. And that too needs attention. Legal data is highly sensitive. We protect medical information in very clear and specific ways. Legal data, even though the attorney-client relationship protects data in one way, the underlying platform data is not necessarily protected in the same way. We need a really serious look into the consumer protection needs that go with both privacy attributes and consumer protection attributes. And we should spend some time on that. We should spend some time educating professionals about the AI-related risks associated with this data sharing. And we should identify ways to potentially, within the bounds of the Keller rules, advocate to the legislature on both information that is legally related and, frankly, the state of our broad consumer protection and privacy protection generally is probably something that merits input from WISPA, again, within the bounds of the Keller rules. So I'll hand that off, Jenny.
Great, thank you very much. I would also, at the end, we'll have questions, but I think pinning ourselves in where we have responded as a bar over time. I'm one of the dinosaurs in the room that when I came out of law school, there wasn't Lexis and Nexis. We went to books and we shepherdized things and we checked them. And then when Lexis and Nexis came on board, if your firm couldn't afford it, they had terminals at the law library. So we are going to be in some really, I think, focused on how do we get ahead of this and how do we, this state, which has always been a leader, set itself up to be a model, not just for its own members, but nationally. So we have some recommended last steps that we're going to talk about, but one is we have to make sure that the regulatory innovation and stability matches up with the ability that technology is changing so quickly. Anyone who's practiced in the area of cyber law knows that once Congress or legislature writes a law, it becomes obsolete almost immediately. And so we as a bar association, we think are going to have some elasticity and some ability going forward to have a set group that is an extension perhaps of our group or others. And we have recommendations about that the board will have to talk about with the courts. But it is going to be very important to have a group who is constantly evaluating where we need to be. It's changing so rapidly. So we have recommendations, including petitioning the court for a standing board, but the Board of Governors may have other alternatives. The importance is to get to that point where this report and the work you do to implement it isn't immediately obsolete or locked in a way that makes it obsolete. So next steps.
So I think the next step is the task force is ready to hand you a report. You've all had a chance to read it. We hope that you will accept the report. We recognize accepting the report is not the same as accepting all of the recommendations therein. And we recognize that any recommendations contained in the report will take quite a bit more thinking, staff work, and so on. So I think that is our handoff moment to you. We also recognize that there are other steps that would need to happen, and indeed that the Board of Governors would need to work with WISBA staff to review and really understand, accept, and implement recommendations, and then implement those through a phased process over time. So I think we'll leave it at that with all of you, and we're open for questions.
Yep.
Thank you so much for the tremendous work that you've done on this. It's just very impressive, and it's exciting, frankly. At this time, I am going to call on Governor Ahern, who may have a question.
Actually, I have two questions, but first, I think what you guys did is great. Because I do a lot of, unfortunately, cyber breach issues. And this is just going to become a disaster, I think, unless we get a handle on this. My two questions, just so I have some background when I'm looking at this. First, with respect to the law schools, and maybe somebody else here knows, how many of the people that take the bar here, our new lawyers, go to the 3 Washington law schools that we have some influence over, as opposed to the other places?
I don't know that breakdown, Governor. I will say that we were very fortunate in early part of this because former dean of the UW Law School, Kelly Testi, was
Right.
head of the National Association of Law Schools, and so she has invited us there as well. So there's been a nationwide discussion, not precipitated by us. Everyone's talking about
Mhm.
this, but the 3 law schools that we had here, I think, were very active. And frankly, we could not have done our work without them.
Yeah.
You know, particularly some of the law students who were much more adept at this and thinking themselves about how they were going to use it. But I think it's an excellent question.
Okay, and then the other, again, just for context, since I represent a lot of school districts, and they are seeing more and more and more AI-generated demand letters, especially like with special ed and stuff like that. From what you've seen, are people pro se just using AI to write their briefs and stuff like that? Is this an increasing issue or what?
You know, we don't have specific data. We have anecdotal data from the judges who served on the task force, as well as other reports. We are seeing a rise in that, and I think it's another reason why it's really important for us to get ahead of that, because there's going to be a balance between the unauthorized practice of law and providing people with tools that may be good. For example, in King County, the vast majority of people appearing on the domestic calendar are pro se. And so being able to give them access to tools would be really important and better than not being there themselves. And so I think that you've hit in a really important issue is people are using this and they're using it for everything, including when they have to go to court. And it's another reason why I think we really have to be thoughtful about what tools do we allow, and the ones we don't allow, how do we educate people why?
Yeah, and I think that's important because I can see the 2 pro ses battling each other. One has some tech savviness, so they have their AI thing, write this really great brief, etc. And the other person's just a victim, basically. And I think we need to level the playing field, and I have no clue how to do it, but I'm glad you guys are going to figure it out.
Thank you.
Yeah.
One thing related to this is in the survey that we did to the members, we specifically asked them how they feel about pro se clients utilizing AI for themselves. And our members do have a lot of concerns about it. The majority of them had concerns about use of AI without the involvement of an attorney. And one of the largest reasons was because they felt like it was jeopardizing their ability to get adequate legal representation. That was one of the reasons, not all of them, but our members do have concerns about it.
Might I will add that survey data from about that time indicated that pro se litigants were using some form of AI tool at a higher rate than attorneys were using AI tools at all. So
Wow.
just pause on that, and maybe to build on that one. I think the other thing was the anecdotal conversations with the 2 members of the judiciary who were in our task force and very deeply involved. Yes, it is challenging for the reasons that you've articulated. At the same time, having people show up with, frankly, better pleadings than they otherwise would show up with turns out to be a major efficiency boost in judicial administration. So that was the sort of the anecdotal conversation. not a broad rule and not an endpoint answer, but an interesting piece.
Yeah, it's just something I see that's going to become a
Yeah.
bigger problem as time goes on.
Governor Villeneuve.
So thank you for that. It is changing the world, and I'm stuck in it right now. I'm general counsel, and one of my problems is what I call the duty to review.
Yeah.
Right. There used to be just facts coming from clients, and now clients go online and they use ChatGPT, and instead of giving me facts, they kind of like think this is my agreement and here it is. And so I have to stop the client and I have to say, wait. And I have an obligation and a duty to review, which my guess is sits on morals and ethics. And I see in your ethical league, that part of it. I was wondering if that wasn't there. I couldn't find that ethical obligation on a lawyer to double check and not rubber stamp essentially AI work that comes in their way and goes out and use it. I understand when we built work product, we kind of like understand that we shouldn't cut corners, but it's very hard to do. And that notion that when it comes from the client, comes from inside, come from a non-lawyer, is that one of the key points here?
You will find it buried in there, but I think part of it isn't addressed as specifically as possible because I would say that the current ethical framework requires a duty of review.
Yeah.
You can never just say to the court what your client tells you if you don't do due diligence, and that's whether it's facts, law, or circumstances. And that duty is going to become more complicated, as you've exactly shown, because people will come with what they think is prepared work product. And we still have an obligation to make sure that what we're representing to the court is correct, and also that we take it and do our due diligence and investigation. So the lawyer's job in many ways stays the same, but it just becomes more complicated.
I might just build on that to note a couple of things, and the first is the aim of the report was not to dig into things that should be settled law, and I think it is settled law that we are responsible for what leaves our offices, and we're responsible for reviewing what comes in. One interesting recent case. This is the second observation. Interesting recent case. It was a sanctions case, but a firm was unable to obtain sanctions in the case of somebody having delivered an AI hallucinated set of cases because the firm that was objecting to these AI hallucinated cases had not found them until the judge found them. The firm had not done its own review of the cases. And so this does complicate the duty of review there as well. We are going to have to learn how to watch what's going on in front of us.
I have a couple extra thoughts. So the task force worked with the CPE, as Jenny had indicated, and we had a CPE member on the task force. And they had us review an advisory opinion that they were working on specific to AI. And so our task force gave a lot of input into that. And just a few weeks ago, the CPE actually approved that advisory opinion. So the advisory opinion will be published as soon as it gets through the Board of Governors in the November meeting, I believe. And that advisory opinion covers a lot of the existing rules and threads them together for members so they understand, and it's very clear what their ethical obligations are under the existing rules. And one of the problems from the survey that we learned is most of our members that reported back on the survey don't believe the ethical rules or questioned whether the ethical rules that exist actually cover AI. And so this advisory opinion does a good job of threading those together for the members so they really understand how the existing rules do apply.
Thank you. Next, we have Governor Bang.
Hi, good morning. Thank you so much for the report. I just want to call out, I think, what wisdom you all started with by focusing on the individual practitioners and inviting us all to take on a posture of humility when learning about this. And I think it's important to say that out loud, and I'll be the first one to admit I have a lot to learn about AI, and I hope we all admit that because it's beyond any of us. I had a question about in writing this report, what your experiences were with working with private industry or maybe on the developer side and seeing what things they're looking towards in developing a product that we, the users, will find useful, and what opportunities we might have in taking a look at your recommendations to really influence the industry and the decisions that they make.
We in going through the practice and in going through the development of the report, we didn't spend a lot of time with technology providers, but we did benefit from both a couple of the large platforms, and we articulated how we did that work in the materials. We had one very strong contributor who came directly. We had a couple came out directly out of industry, but one who is very active right now in this particular set of issues, and that was Jacqueline Schaefer from ClearBrief. And in fact, ClearBrief is an AI-driven system that is very happy to solve this review of the other party's documents for you problem because they do case citations and citation checking. And so there were very interesting tools that we saw there. I think that is a specific solution that I'm very enthusiastic about. But the imagination kind of reels with the possibilities inside the practice of law, given the breadth of the practice of law. Yeah.
And we tried again, as I said, we went to Microsoft was very good to take us not just through their cybersecurity center, but we spent a great deal of time with their senior lawyers on how they've been able to roll out AI. And it actually was very eye-opening. They're, because their teams, they record all their team meetings. One of the people who was presenting to us would just come out of a meeting that was supposed to be 30 minutes. It was 90 minutes. He had to get a memo to the executive committee. So he just showed how he did it. He just clicked on his calendar and he said to the AI prompt, please summarize this meeting in a memo form and focus on the following 5 things. Boom, boom, boom. And under a minute, he had a 90-minute meeting summarized. Now, of course, he's going to review that before he sends it up the chain, but you can see, we had another demonstration by a vendor who is excellent, and they, the query was, okay, well, show us how you work. And I said, pretend you're the lawyer in a real case. So I said, okay, I'm representing Microsoft. They've just been sued by the New York Times. Real case pending in New York. He pulls up the complaint. He goes, what do you want to know? And I gave a very long prompt. It was, take each of the claims. I want them analyzed under Third Circuit law, Fifth Circuit law, the EU law, blah, 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 blah. I mean, I really loaded it up. He read it back to me. I said, no, let's add a few more things. And he read it back, gave it to the AI platform that he uses. And we continued talking. In under 2 minutes, I had over a 30-page memo that if an associate gave it to me, I'd give it a B. Now, I didn't do all the checking, but you can see that would have represented hundreds of hours maybe. So why we have to retool how we do stuff, I think, is just so critical.
I have one more comment about how we work with businesses going forward. So right now, the WISBA offers discounts through our practice management discount network, but we really want to expand this program and really have partnerships with vendors to help us teach our lawyers what kind of technology exists and how to use it. I think we all know you don't know what you don't know. And I think a lot of that's with technology. So getting in front of members with just demonstrations and having opportunities for them to have one-on-one as well as, so that's one of our recommendations to expand to support our members working with other businesses.
Governor Bloom.
Yeah, thank you for the presentation and all the work and wrangling of all the parties, because I understand this is a huge enterprise. There are a lot of folks involved and very informative. A couple of observations, I guess. One of the things, I mean, it seems like and largely maybe comes from my experience as a parent of a college student, recent college graduate and whatnot. But how embedded AI is even in undergraduate curriculum, that most kids going to law school or young adults going to law school, or even older, but particularly the younger cohort, are getting a lot of this in their undergraduate curriculum, are using these tools, are quite familiar with them by the time they get to law school or get into practicing law. So I think this is going to become a non-issue or at least we'll be juggling a lot different aspects of it perhaps in the future than we are right now, because our cohort now, the 40,000 are in the dark. Our up and comers are going to be fully prepared with experience and background and firsthand usage of this, and so it's not going to be anything for them, right? So this is really kind of, it seems like it's a transitional thing where we kind of get folks who didn't kind of come up through this experience, to be able to utilize these astounding, just unbelievable new tools that we've got, right? So that's just an observation that our challenge in the law schools may be extremely short-lived, and it may just be integrated, and then it's just a function of managing it and putting the guardrails around it, particularly from an ethical and legal ethics perspective. The other thing I thought about that it kind of has occurred to me in the past as well is that this concept that pro se litigants are using it even more so, quite a bit more so, maybe twice as much as the attorneys are using it. Of course, there's the reticence about it with regards to the parameters of, client confidentiality, the nature of the legal claims, things of that nature, different aspects that cause some reticence or reservation about professionals, because I've used it some, but I don't have it fully integrated in my practice now, and I understand quite a bit about it. But again, largely to the fact that I've got a college student, kind of shepherded me along that, right? And I advise everybody, if you don't have one, get a college student.
He's offering his son.
but it's incredible how how effective this is and how potentially, powerful it is, right? Not even potentially, just how powerful it is. And I think that, one of my concerns is to the public's view, because we see this not just in the law, but all over, radiologists. AI can read X-rays, better than most radiologists, is what we're discovering now, right? Now, radiology isn't just going to disappear as a profession, necessarily, because they're going to adapt and they're going to be able to add some value and they're going to be able to utilize this. But, I think that there's a particular concern that, whether the legal profession is going to continue to exist in a decade or 2 decades from now, because, public confidence in, and I think that that's really kind of our concern. It seems like it should be part of our concern, certainly, is with regards to, public perception of the law as a learned profession that's even necessary, because you've got AI who can do that for you. And so I think that there is an imperative and an urgency, I think, for the legal profession to get on board and be able to figure out how we add value on a going forward basis to be able to sustain the legal profession in the AI environment. So.
And I just jumped ahead of Jenny to pick up on that, on the learned profession comment. This is our time to be a learning profession, not a learned profession. Okay? Everybody. All of us. It's our time. It's our time to be a learning profession. And I don't worry about lawyers being replaced by AI. But if I'm not using AI, I worry about being replaced by one who is. And I think those are the places where my sensitivities are, at least in the near term.
What he said. The other thing I'd add is, I think the more you practice law, the part you enjoy is actually the counseling part, the wisdom part, the experience. And that's what the clients really rely on. And I think that's not going away. And that if we do this right, really, these are tools that are going to free us up to do those parts that really set our profession apart.
I mean, I will jump in. I use several different AI tools every day. Half of my billable hours contain some use of AI. It is making me better at my job. It is the reason that I can serve a client like a Microsoft and I can compete with Covington as a solo practice. I couldn't do that without this stuff. Word and Excel alone aren't going to do it. And my little brain isn't going to do it. So I would just offer that there is real opportunity in here.
I have one more comment. So although we're talking about sophisticated technology like AI and data analytics, there are some serious issues with how lawyers even utilize their their laptops or their printers. There was recently a study done in medium-sized law firms, and the respondents reported use of AI, but they also said the issues that were coming up in their office was their computers were old and they weren't even being updated, which is a huge security risk. And these were like some of the most, like the respondents provided more information on this than really anything else. So I think that's really what we have to get down to as well, is what Craig said about the Panama Papers. You know, we have actors that are able to get in. Wasn't there a big hack through printers, for instance? So teaching our lawyers how to utilize their technology in a way that's safe, I think it's going to be huge. And that's where we have to bridge the gap between the older lawyers and the newer lawyers as well. Something I see.
Can we say experienced?
Experience. Yes, experience. In the practice management consultations I provide, these are confidential services. Something that comes up all the time is one, shame. Lawyers feel a lot of shame in not knowing about technology. And I say, I'm asking you when you took your last word class, not to upset you, but just to show you that it's important to continue learning on your everyday tools as well, and to have that part of your work. And then the second thing I see is that there are some lawyers in firms who are up with technology and excited about it, but the firm hasn't embraced it. And what that does is it just creates a lot of disconnect and creates frustration and other issues as well. So I think that's where this education piece comes in. It's sophisticated AI, but also use of our computers and everything else.
Yeah, and I'll just add quickly to that because I know we were trying to wrap up, but putting on an old hat when I was U.S. attorney and in charge of a lot of DOJ cybersecurity things, there are bad actors. And those bad actors are using AI right now to get into people's computers. And so if we can't help our members have just the basic kind of security, we are going to be exposing their clients' secrets to bad actors, which then is going to diminish our public standing, let alone hurt those clients. And so I think it's really incumbent upon us to take these steps, because this technology, I believe, could be the thing that really does close the access to justice gap by leveling the playing field, or it could exacerbate that gap because it ends up in the wrong hands and there isn't equal access, equal education, and it's being utilized by people who perhaps motivations aren't pure.
Thank you. Next, I'm going to call on Jordan Couch, Governor Couch, and then Governor Wen. I do want to remind folks of our timing issues. This is such an amazing topic and an amazing presentation. So I don't want to curtail discussion, but please, if we can, keep it brief. Thanks.
I want to thank you for all the hard work done on this. I shared this with all of you yesterday, but others should know that the work of this task force has already been cited in court opinions. Unfortunately, that was a court opinion very thoroughly and well sanctioning someone for the improper use of AI, but this work is already having an impact and will have a positive impact in the future, I'm sure. So I would move to accept this report, and I would ask that it be sent to the executive committee to review and delegate next steps.
Second.
Great. Governor Wen.
Thank you. I just have one question, and I know that courts are concerned with lawyers using AI. Are the court having any plan to implement AI themselves?
I think that varies from court to court. We were lucky to have the two judges and also dialogue with the Chief Justice, but I think there's huge disparities on the level of understanding from judge to judge and district to district, and depending where there are. So I think that you have some who are very eager. One of the judges who applied for the position sent a video in on why he thought it would be good for him to be selected. And he talked, and at the end he said, and I promise if you select me, I'll show up in person because this is AI generated. And he had generated his own deep fake. So I think it's why we think our recommendations about the courts is central to success.
Yeah. So we have a motion on the table and it was seconded. Anyone has any last comments? Please speak now. Otherwise, I think we're going to go to a roll call vote.
Okay, this is on the motion to accept the report and send it to the executive committee to delegate our responsibilities. Christina Larry.
Aye.
Todd Bloom.
Aye.
Jordan Couch.
Aye.
Chris Bang.
Yes.
Kari Petrosic.
Aye.
Tom Ahern.
Yes.
Allison Whitney.
Aye.
Mary Rathbone.
Aye.
Harvin Price.
Yes.
Alain Villeneuve.
Yes.
Kevin Fay.
Yes.
Emily Arneson.
Yes.
Nam Nguyen.
Yes.
Matthew Dresden.
Aye.
The report has been accepted unanimously. Thank you all.
Thank you so much for your presentation. And I just want to say this is just the beginning. Our board is definitely going to be looking at the implementation piece. So we thank you for the work you're doing, and we hope you'll continue to stick with us.
Thank you very
Big
much.
thanks to Chair
We-
Jack.
And,
too.
and a special thank you to Jenny Durkin for
It was
taking
it was
this
a
on.
Whole team effort. Thank you.
Okay. Yeah. We're going to take a 10-minute break. So see you all back at 10:55.